All right, it's the appointed time. The people are in the seats. We have a full house. The AV crew is there. Let's go ahead and get started. Hi, everybody. I'm Michael Scharf, the co-dean of the law school. On behalf of the faculty, its staff, its students, its alum, everybody, we're really happy to see you here. When I look out in the audience, I see some students, I see some alum, I see some people from other parts of the and there are going to be about 1,000 people watching this on YouTube, so hello to all of you as well. This law school is very fortunate to have a robust international law program. This year it was ranked number 11th in the country under the US News rankings, putting it ahead of Stanford and Cornell, and we're very excited about that. And part of what makes it special is the event that we're having today. We have a $4 million endowment that backs up our international law program, which includes money for the projects we do, for the conferences and the lectures, and also to send our students, many of whom are in the audience, all around the country, all around the world, like the American Bar Association's Rule of Law Initiative. The jewel of our events is the annual Cox Center International Humanitarian Award for Advancing Global Justice. It has been called in the press Cleveland's Nobel. It was established in 2004, and its past recipients have included such luminaries as Harold Koh, the State Department legal advisor, Fatou Bensouda, the chief prosecutor of the International Criminal Court, Navi Pillay, the UN High Commissioner for Human Rights, Thomas Bergenthal, the judge of the International Court of Justice, and others. This year, we are very excited that the committee has chosen Elizabeth Betsy Andersen to be our recipient. A graduate of Yale Law School with a master's from the Woodrow Wilson School of Public and International Affairs at Princeton University, Betsy has served as Executive Director of Human Rights Watch's European and Central Asia Division, as legal assistant to Judge Abi Saab of the International Criminal Tribunal for the former Yugoslavia, as Executive Director of the American Bar Association's Central European and Eurasian Law Initiative, as Executive Director of the American Society of International Law, and now she is Director of the American Bar Association's Rule of Law Initiative, which is known as ABA-ROLI. ABA-ROLI is the ABA's $49 million international development assistance program. Projects are all over the world in 60 different countries. They have 650 personnel, including one of our own alums, Nikki Desarathi. Betsy has spent her years traveling the world, leading projects in human rights and transitional justice. It is my great pleasure to present Betsy with our unique honor for her inspired leadership, her dedicated service, and her impactful work throughout the world. Her Humanitarian Award lecture, which will follow in a moment, is entitled From Transitional Justice to the Rule of Law, Lessons from the Field. Please, everybody, join me in congratulating our award winner this year, Betsy Andersen. Couple more shots. And one more. Put this way, please. Thank you so much. Okay, without further ado.
Thank you. Thank you so much, Dean Scharf. It's really an incredible honor. I'll put that up there so that my watching can see it. It's really a great treat to be here, and I really appreciate the award and the invitation. Very kind introduction. It's always fun to come to CASE. You are very lucky to have in your dean someone who is a tremendous convener of diverse people from practice, from theory, from academia, for discussion of the international law issues of the day. And I've been fortunate to be a part of a number of those conversations over the years, and it's really terrific to be back. I should say that Dean Scharf is also one who knows how to throw some fun into such gatherings. And last time I was here, we went over to the Rock and Roll Hall of Fame, which was a real highlight of that trip. And I have to think now, I run the American Bar Association Rule of Law Initiative, ABA-ROLI, or as I've come to know, and as a child of the 70s, I kind of delight in this. Around the world in other languages, ABA-ROLI is known as ABA-ROLI. So Maybe there's a place for me in the Hall of Fame. It's really an honor to receive the Cox Center's Humanitarian Award, but I hasten to admit that my experience and insights into international humanitarian affairs have really been gained on the backs of others. My colleagues at the ICTY, Human Rights Watch, ABA Sealy, and now ABA Roli, who are on the front lines of the development and implementation of humanitarian norms all over the world. I'm incredibly grateful for the opportunities that I've had to work with them, to learn from them. But I should also say that the comments that I make today are very much my own. I imagine that some of my current and former colleagues would disagree with some of the things that I'm going to say. And I trust it goes without saying that I certainly am not here speaking on behalf of the American Bar Association. I pity the person who tries to speak on behalf of 400,000 lawyers. So this is very much from me and my reflections on the relationship between transitional justice and rule of law that I have observed over the years in my work. I want to focus on these two fields, transitional justice and rule of law, as concepts and as fields of scholarship and practice, to propose a reconceptualization of transitional justice in rule of law terms, and draw some lessons from the rule of law development field in which I now work about what such a reconceptualization means for how we do transitional justice. Over the past 2 decades, these two fields, transitional justice and rule of law, have advanced significantly in both theory and practice. Transitional justice has seen the development of numerous models and approaches and come to encompass everything from traditional criminal procedures in the form of international courts and tribunals and hybrid and special courts, to expansive programs of lustration, reparation, truth and reconciliation, and commemoration, all in the transitional justice bucket. Over the same period, the modern era of rule of law development, launched in the aftermath of the fall of the Berlin Wall, has similarly yielded a wide array of tools and an increasingly sophisticated appreciation of the change in this complex arena and of the role that rule of law development plays in development and international policy goals. There's some healthy debate about what the rule of law means, what the definition of the rule of law is. But for my purposes today, and for reasons that will become apparent, I would like to embrace an expansive version of rule of law, encompassing both the laws and institutions and procedures that ensure transparent, effective, accountable governance, and also the substantive human rights norms that ensure that that governance is accessible and equitable. Rule of law development programs include ambitious legislative and institutional reform and capacity building efforts, court administration and automation programs, judicial and prosecutorial training, programs such as these, all aimed at expanding the supply side of justice. And also, rule of law encompasses civil society support, human rights litigation and advocacy, public education, know your rights media campaigns, all these kinds of initiatives that are aimed at bottom-up building demand for justice. Billions of dollars are spent on both transitional justice and rule of law development each year, with significant, seemingly obvious potential synergies between these fields. In the early 1990s, we had a rather narrow concept of transitional justice and rule of law. Transitional justice meant a court in The Hague, and rule of law development assistance meant a training program in the country concerned. There seemed little relationship between these two projects. Today, however, transitional justice focuses on building national, prosecutorial, and judicial capacity. Indeed, the field prioritizes those kinds of solutions under the International Criminal Court's complementarity regime. And that puts transitional justice very much squarely in the rule of law development business. And as both the rule of law and transitional justice fields embrace rights-based approaches and seek to empower victims and devise bottom-up solutions, these efforts are, or should be, closely intertwined. But for the most part, in practice, these are still very distinct fields. The reasons for this disconnect between rule of law development and transitional justice are multifold. The fact that the two fields stem from traditionally distinct fields of scholarship and practice. International or transitional justice was traditionally the realm of lawyers, particularly human rights lawyers and activists. And rule of law development was the province of a mix of development experts, political scientists, and comparative law professionals. In more practical terms, on the ground, there are often real or perceived conflicts over the prioritization, sequencing, and resources for transitional justice and rule of law initiatives. In an aside, in a 2013 article, leading scholars of transitional justice, Catherine Sikkink and Hunjun Kim, summarized the prevailing view as follows, quote, "A better quality rule of law is neither a necessary nor a sufficient condition for transitional justice. Developments in the rule of law have contributed to transitional justice, and the success of some transitional justice measures may in turn enhance the rule of law." So to paraphrase, there's a loose but not essential association between these two. We pursue justice and we pursue rule of law, and sometimes, maybe coincidentally, maybe if we're really good or just lucky, they will reinforce each other. That's kind of the prevailing sense in scholarship and practice. But I find that profoundly troubling. If that's the case, and I fear that more often than not it is, then there's something seriously wrong with the way we're thinking and doing both transitional justice and rule of law. What, after all, are we transitioning to with these justice efforts, if the rule of law? Shouldn't we be doing that consciously and intentionally? I'm with UN Secretary General Ban Ki-moon, who concluded in his 2011 report on rule of law and transitional justice that though linkages between transitional justice processes and institutional capacity building have been strengthened, greater commitments to integrate our approaches are required going forward. That's an understatement, I would say. In fact, I'm going to argue here today that we should conceive of transitional justice as a rule of law project. That is, we should design, sequence, and pursue transitional justice to advance the rule of law. Rather than justice as the principal goal, in this conception, it is a means to an end, the rule of law. Or to put it another way, I would suggest an expansive understanding of transitional justice, in which the reestablishment of rule of law is justice. Now, I appreciate that coming from the director of the Rule of Law Initiative, this may sound a little self-serving, and maybe like a case of where you sit is where you stand. But I think that reconceptualizing transitional justice as rule of law, or in terms of its rule of law impact, makes moral and ethical sense and brings welcome clarity of purpose to the transitional justice field. Let me explain why. Challenges encountered in any transitional justice effort is identifying and clarifying its goals and designing processes and projects that can fulfill those goals. In the politically charged and complex environments in which transitional justice unfolds, there are often many varied goals articulated by different stakeholders in the process, with no clear prioritization among them. I first encountered this conundrum when I was a law clerk at the Yugoslav Tribunal. And I was there during the first case to come before the tribunal, and the first question presented to the court, to the chambers, was whether or not the tribunal had been lawfully established by the Security Council. So being a dutiful law clerk, I went to work researching that question, and it turned in part on whether the UN Security Council was acting within its powers to establish the tribunal. And so to think about that, I thought, well, we need to know what the Security Council was doing, whether what it was doing there was within its articulated powers under the UN Charter. And so I looked at the resolution. I looked at the Security Council about what the Security Council said it was doing when it established the tribunal. And my co-clerks and I, we found no fewer than 6 different purposes for the tribunal articulated in those proceedings and in that resolution. Now, Dean Scharf was on the other side of that activity. He could probably tell us what the Security Council thought it was doing, but I would say on the face of those documents, it's not at all clear what the goal of the tribunal was. And that is more often than not the case in those kinds of founding documents of transitional justice mechanisms. The goal of transitional justice can be varyingly or simultaneously identified as peace, reconciliation and social cohesion, retribution, punishment, restitution, reparation, truth-telling, vindication and validation of an experience, deterrence, prevention, reform, and development. What the goal is may affect the transitional justice mechanism selected. And what you do to achieve retribution may be very different from what you do to achieve reparation or reconciliation, not to mention the elusive truth. In some cases, different transitional justice tools serving these different goals can be deployed simultaneously. But in others, they may be in, or simply limited resources may require prioritization of strategies to achieve one goal over another. How should the transitional justice field make these choices? I would like to suggest that reframing the principal goal of transitional justice as establishing or reestablishing the rule of law can help sort through, prioritize, and reconcile these sometimes competing demands. This approach takes as its starting point the idea that prevention is prioritized among all the possible goals for transitional justice, positing that the principal goal for transitional justice interventions should be non-recurrence, to guarantee never again. And this approach also assumes that the most effective prevention strategy is a well-developed rule of law, defined broadly to encompass not just effective and efficient justice sector institutions, but also guarantees of basic human rights such as due process, fairness, and equality, and indicia of good governance such as transparency and accountability. Why do I think that this is appropriate? Well, actually, most of the other purposes articulated for transitional justice have at their root prevention or non-recurrence. Some have important ancillary or independent benefits, for example, for victims. And I don't want to dishonor victims, but I do think that the morally defensible choice as between a measure that serves victims and one that prevents future victimization is the latter. And we know that rule of law states are more effective at preventing atrocities by providing a check on abusive state power and by offering legal and peaceful means of addressing the kinds of grievances and conflicts that give rise to atrocities. Reframing the purpose of transitional justice as reestablishing the rule of law provides a mechanism for choosing among transitional justice approaches and processes. And this mechanism is both principled and flexible, accommodating context-specific transitional justice solutions that contemporary research shows are most effective. In one context, Reestablishing the rule of law may require vetting and lustration of security forces responsible for abuses. In another, truth-telling or reparations processes that help reestablish a broad-based rule of culture may be in order. In this conception, prosecutions are justified on the contribution they make to the rule of law over the long term. Short-term or particularized interests, such as punishment or retribution. The role of victims, too, is defined with an eye to the requirements of reestablishing the rule of law. For example, this approach might favor a process and mechanisms that reach victimized populations broadly, reestablishing a widespread confidence in and appreciation for the rule of law over, on the other hand, robust individual victim participation in individual criminal prosecutions. Such individual victim participation might be important to a particular victim, but may have a limited rule of law impact. And again, with a focus on reestablishing the rule of law, we would be able to select among different models for victim participation. Such an begin with an assessment of the rule of law context, the gaps in the rule of law that permitted atrocities to take place, and the critical elements of rule of law required to prevent them in the future. These assessments could take advantage of best practices in rule of law development assistance, including participatory research in communities, local ownership of program design, sustainability guarantees, and plans for monitoring and evaluating the intervention over time. In each case, design of the transitional justice response would be part of and consistent with a comprehensive assessment of the elements required to reestablish the rule of law. Which transitional justice tools are used and how they are sequenced, designed, and deployed would hinge on their contribution to building the rule of law in the particular transitional society. A rule of law-based approach puts the emphasis on transition rather than justice, or rather it privileges justice that has transitional impact on the long-term rule of law over justice, in the more traditional judicial process sense, simply for justice's sake. Such an orientation brings much needed clarity of purpose to transitional justice initiatives, and it promises efficient and effective use of scarce resources for justice interventions, training those resources on interventions most likely to have significant long-term impact, and intentionally taking advantage of important synergies between justice mechanisms and the development of rule of law. So let me elaborate the implications of a rule of law approach to transitional justice with some particular examples from the rule of law development field. What does a rule of law approach to transitional justice mean in practice? What do we know about effective rule of law development, and in particular, the effects of different kinds of transitional justice on rule of law that this reorientation, putting rule of law first, would bring to bear on transitional justice? What lessons are there from the rule of law field that can inform a rule of law approach to transitional justice? As you begin to think about transitional justice in rule of law terms, your focus changes. Different elements of a transitional justice strategy become more important, including some that might be considered optional when designing transitional justice processes with a justice frame. But these become critically important if the central goal is reestablishing the rule of law in a transitional society. Let me highlight a few of these elements. First, when you take a rule of law approach to transitional justice, modeling the rule of law in that process is essential. It would seem obvious and uncontroversial to insist that transitional justice initiatives adhere to fundamental principles of legality, procedural fairness, and even-handed and non-discriminatory application of the law. In short, that they model the rule of law. Certainly, if the principal goal of the process is to reestablish the rule of law, this becomes essential. Yet time and again, throughout the past 20 years of transitional justice experimentation, policymakers, prosecutors, and judges, focused narrowly on a justice imperative in the traditional sense, have cut corners in ways that have seriously eroded the rule of law in post-conflict settings. Rule of law lapses, such as the detention of alleged perpetrators without charge in Cambodia, the one-sided victor's justice in Rwanda, or impunity enjoyed by Indonesian military leaders for crimes committed in Timor-Leste, can be rationalized as unfortunate but necessary compromises in service of a higher goal of justice, at least in the short term. The counterfactual, of course, is to prove, and only time will tell. But I would suggest that such shortcuts undermine the legitimacy and impact of transitional justice and may have long-term deleterious rule of law and human rights implications. A rule of law approach to transitional justice eschews such shortcuts and requires accountability and careful respect for certain fundamental procedural rights, even or maybe especially outside of formal legal proceedings in truth-seeking or other consultative transitional justice processes. Special care should be taken to ensure the process is accessible to marginalized populations. Efforts to engage local affected communities in transitional justice process design are salutary, but should be carefully pursued to avoid reinforcing traditional power structures or discrimination against or exclusion of disadvantaged groups. Work that ABA Rowley has done recently in Guinea and Mali to facilitate local input into transitional justice processes has underscored the importance and difficulty of ensuring such participation and inclusion. Special effort is necessary to ensure the participation of women and other traditionally marginalized populations, insisting on their representation, or taking the process to them to places where it is accessible or where their participation is acceptable. What we begin to see and appreciate when we take a rule of law approach to transitional justice is that the process itself may be as important as the outcome. Traditional judicial forms of transitional justice approaches focus perhaps excessively on the outcome, the verdict, the sentence, with clear winners and losers, the rule of law on one side and violence, oppression, atrocity on the other. But if we widen our focus to encompass the process and to make the most of that process, that approach can help ensure that rule of law is always the winner, whatever the verdict or outcome. To ensure that rule of law is always the winner is to demand rule of law in the transitional justice process, to make that process transformative of existing practice, norms, and power structures. Thus, for example, in Mali, where ABA Rowley is working with local partners to use the religious justice mechanism known as recourse to the Qadi, or Islamic judge, a widely recognized and resonant local practice, it is critically important as we do so to introduce attributes to that process, guaranteeing equity, fairness, and predictability. Otherwise, that recourse risks reinforcing problems or laying the groundwork for revenge and new atrocities. The transitional justice process is a critical opportunity to reset the public's expectations of and confidence in the rule of law. Failure to seize this opportunity, and worse, lapses or shortcuts that reinforce skepticism about the rule of law or sow seeds of grievance and injustice through an imbalanced or procedurally flawed transitional justice process can set the transition back by years. So the first takeaway to law approach is the importance of modeling the rule of law in transitional justice. A second important set of implications to this approach to transitional justice is the importance of localizing the justice. This aspect of rule of law-based approaches to transitional justice emphasizes their engagement with and relevance for term contribution to the local affected community. This was a lesson learned early in the history of the ad hoc tribunals for Yugoslavia and Rwanda, where trials conducted in English and French in The Hague had little resonance or positive impact on the affected populations. Indeed, they were susceptible to distortion in those affected populations, a distortion that risked radicalizing elements of the population. And they did nothing to develop the capacity of local justice sector institutions. Belatedly, the ad hoc tribunals developed public awareness and media campaigns to explain the procedures and counter misinformation about them. And subsequently established tribunals have been more intentional about outreach. But I am just back, day before yesterday, from Belgrade, and I'm sorry to report that the Hague Tribunal still has little resonance or credibility in that population. This is not to say that it was a mistake, but that a rule of law approach to accountability and to design and development and implementation of that institution might have taken us down a different and more impactful path. More successful in rule of law terms in Serbia has been the Special War Crimes Chamber in Belgrade. Its verdicts have more resonance and impact locally. And it has served as an important incubator of rule of law reform for the national justice system. I was there to work with criminal defense lawyers on developing capacity for the effective criminal defense in the context of implementation of a new criminal procedure code. And that code was first introduced, trial tested, if you will, in the special chambers in Belgrade. Selected where the judges and lawyers and prosecutors had the greatest capacity, had been trained, and where they would have an opportunity to work out the kinks in that new criminal procedure code. Just one example of the impact, long-term rule of law impact that a locally situated transitional justice initiative can have. More recent years have seen a proliferation of such hybrid and special court models located in or near situation countries and tapping national as well as international figures as prosecutors and judges. These processes not only promise to be better understood by affected populations, they also develop critical justice sector infrastructure and human capital that is essential for reestablishing the rule of law over the long term. An appreciation of the benefits of local understanding and ownership of accountability efforts also informed the design of the International Criminal Court, its complementarity regime, and the primacy that it gives to national proceedings over international justice. Ironically, however, the Yugoslavia and Rwanda tribunals, through their practice of transferring cases back to national jurisdictions once certain conditions are met, have in the end done more to spur rule of law development in the affected countries than has the International Criminal Court in the situations under its jurisdiction. Prioritizing rule of law in transitional justice efforts might suggest a different approach to the ICC's complementarity jurisprudence, one that is more deferential to national prosecutorial discretion, where that discretion is exercised, of course, in a manner consistent with the rule of law. This rule of law approach would also commend strategies such as that used by the ICC at the moment in the Ntaganda case, where the court is conducting the hearing on confirmation of the charges in the district in which Ntaganda is perpetrating atrocities in 2003. A rule of law-based approach also dictates the development of mechanisms currently non-existing for transfer of cases to capable national courts, as was the practice in the ad hoc tribunals under their Rule 11 bis jurisprudence. A rule of law-based approach also, of course, dictates investment in national capacity to prosecute war crimes or positive complementarity. This is an approach that the American Bar Association has undertaken in the Democratic Republic of Congo, where we are working together with prosecutors and judges, developing defense capacity as well, civil society organization, to bring to justice those responsible for sexual violence, an epidemic in that context. We have, through that work, provided assistance to 18,000 victims and taken some 3,000 cases to court and achieved 1,300 convictions. Our theory of the case, our theory of change, is that impact in the local environment will contribute to establishing expectations about the rule of law. I think it would be an interesting empirical study to compare the perceptions and impact of the ICC work in the DRC and the work of Rowley and the other implementers working on developing the capacity of those mobile courts and accountability at the local level, and to evaluate the relative benefits for the rule of law. Conceiving of transitional justice principally as a rule of law development project also invites adaptation of valuable, consultative, and participatory approaches to engaging local populations in transitional justice process design. Local consultation and ownership have long been recognized tools of effective development. More recently, these methodologies have been deployed in transitional justice process design, and they are a new USAID practice guide on community participation in transitional justice, developed by ABA Rowley last year on the basis of our fieldwork in this arena. Such methodologies take as a starting point for transitional justice project design a deep understanding of the local, social, economic, and political context, and broad consultation among justice stakeholders about their needs, interests, and expectation of transitional justice. In short, what does justice mean for them? These consultative processes can yield solutions that are locally meaningful, address real contemporary needs, and would not be apparent to outsiders, and may have a long-term, more significant rule of law impact than a more traditional judicial process. Thus, for example, in the case featured in the USAID guide, ABA Rowley worked with local community civil society organizations in Guinea. And here we were facing a context in which there were 30 years of growth of human rights and atrocity, and an interest in righting those wrongs in a transitional justice mechanism. And through that consultation with the local community, we had identified a solution that was meaningful to them. And it was a surprising one. The community, because of the poor governance and violence, had been isolated economically and politically from much of the rest of the country. And from those consultations was their interest in a remedy that would reverse that effect. The solution, the transitional to build a new road connecting the remote area of this village to the city, and having that road dedicated to the memory of the victims of that 30 years of repression. The community wanted their suffering, their victimization to be recognized, validated, a reckoning for it, and they wanted a remedy that would improve their lives going forward. Such participatory or consultative processes can not only produce valuable transitional justice strategies, but also lay an important foundation for the long-term rule of law by empowering local populations and equipping them to play an ongoing important role in advocating local interests and holding actors accountable. They are practicing the rule of law in the context of the transitional justice process. This is the strategy we are pursuing in Mali, where ABA Rowley has facilitated the publication of a transitional justice strategy drawn from a series of community dialogues about what the communities wanted. The strategy itself is an important outcome that we hope will resonate with the authorities. But so too is the experience of the participation and of a mechanism for peaceful expression of grievances and expectations vis-a-vis power structures. One important condition for participatory approaches being successful and contributing to the long-term rule of law is that there be a fit between the local participatory process and the expectations it creates on the one hand, and the outcomes that are politically and practically possible on the other. A mismatch that leaves local needs and expectations unsatisfied can reinforce feelings of injustice and, of course, undermine the rule of law. Thus, a critical element of such participatory or bottom-up transitional justice strategies is that they be integrated into state-driven transitional justice initiatives, that reality test the solutions as they are developed, and that there be political will for their implementation. So to summarize that set of lessons for a rule of law approach to transitional justice, localizing the process is critically important. A third effect of taking a rule of law approach to transitional justice is that it expands both our toolbox and our time horizon. In the transitional justice field, we tend to talk about measures, mechanisms, discrete time-bound projects that provide an account bring closure. In the rule of law development field, on the other hand, we talk about programs, strategies that by definition are iterative and responsive to unfolding developments, needs, and opportunities. Rule of law development efforts employ a wide range of tactics, from legal reform to training, litigation and legal services to public education campaigns. Each of these can have, at least implicitly, a transitional justice component, providing an accounting, righting a wrong, setting the record straight, or providing a remedy, often a systemic remedy rather than an individual remedy, but I would argue justice nonetheless. I was recently in Charleston, South Carolina, to bring us closer to home. And while I was there, I was struck by tangible signs of transitional justice I could see. There were plaques that commemorated the work of Thurgood Marshall and Martin Luther King in that local community, in an plaque in the local courtroom, and the district court judge there very proudly telling the audience that assembled for the event that I attended about the role that Thurgood Marshall played in winning a seminal desegregation case in that courtroom and how desegregation started there. I was struck that there was a clear effort on the part of local authorities to account for past wrongs and take pride in, take ownership of a new rule of the future. You may have read of the Equal Justice Initiative's efforts to account for widespread lynchings in the South between the Civil War and World War II. In a report, they have documented 4,000 such murders used to enforce Jim Crow laws and segregation, often carried out in public and attracting hundreds and even thousands of spectators, with families posing next to corpses for photographs. It's really a horrifying story. I think the national conversation we've been having about discriminatory and excessive use of force by police and the Justice Department's recent report on policing in Ferguson, Missouri, is also a part of this transitional justice story, as is the work of my own organization, the ABA, on the issue of over-incarceration in our country and the school-to-prison pipeline that proportionately affects minority populations. All of this effort on the part of civil society, government, all of it can be understood as a reckoning, a transitional justice, providing a step toward a more robust and inclusive rule of law. Taking a traditional approach to transitional justice, one would not be very satisfied with accountability for slavery, segregation, and all of the related violence that has occurred in the United States over the past 300 years. A rule of law frame provides a different take on this failed transitional justice effort. An appreciation that this is a long process and that we still have many mechanisms at our disposal to provide an accounting to reconcile that past with a rule of law future. I want to be very clear here. I am not urging patience or complacency. Actually, the opposite. I am urging a conceptual move that I think can turn grievance and defeat and guilt into a strategy for accountability, reckoning, and reform. A strategy that cannot undo the wrongs of the past, but that can avoid further victimization and make a difference in the future. 20 years of experience in the modern era of transitional justice has underscored the importance of holistic solutions that combine community-based processes of truth-telling and reconciliation with formal accountability and reparations regimes. Such calls often refer to the importance of taking account of the rule of law context in question to develop effective transitional justice solutions. In my talk today, I'm suggesting flipping this approach, putting rule of law development as the principal goal of transitional justice, and developing a holistic transitional justice strategy that serves this goal. I've suggested a few ways in which I think this reorientation would change the way we think and do transitional justice. But these are based primarily on anecdotal field experience. This emphasis on the rule of law effects of transitional justice calls for a lot of new research, and that's where you all come in academia. We need research on what actually works better, why, when, and how. There is a growing goldmine of data about transitional justice mechanisms used over the past 20 years and their impacts on the rule of law. Early research suggests some interesting findings, such as the fact that prosecutions work in improving human rights, especially local prosecutions. They work even when they end in acquittals or when they occur in neighboring countries. But here's an interesting wrinkle. The findings also suggest that prosecutions are particularly effective when they are accompanied by an amnesty law. There are lots of theories about why that may be the case, but ripe for research. Another scholar suggests that while prosecutions are effective, litigation before regional human rights bodies, judgments against states rather than individuals, judgments forcing systemic change, can be more impactful. I was struck when I was recently in Central America, a number of reforms with justice sector actors there, how many times they raised decisions of the Inter-American Court of Human Rights as the reason for what we were doing together. They were seriously preoccupied with how to implement or comply with these decisions. So there's clearly an important rule of law impact there that we need to mine. We still know very little about the relative benefits of all of these different transitional mechanisms, how they contribute to the rule of law. And we know virtually nothing about the best way to sequence them. So let me leave you with those challenges to study this incredibly fascinating and important field and help those of us find who are working to advance the rule of law, find the most effective strategies for doing so. Thank you very much.
So we have time for questions. There are microphones. Please wait for the microphone to come to you.
Yes, I have a question. You mentioned Thurgood Marshall. You mentioned your observations in South Carolina as well as international. How impactful can the federal judiciary be regarding rule of law and transitional justice, as you mentioned it within your in the context of various different things that are going on today vis-a-vis the Justice Department, because they seem to have a little bit more less impact in terms of being influenced politically because they're in for a lot of the federal judiciary. So how impactful, given the history of them within the voting rights, desegregation, et cetera, relevant to the rule of law and the other topics that you mentioned?
Right. Well, I think the federal judiciary is actually a critical safeguard of the rule of law in this country. We've seen that over and over again. And I think the life tenure is a critical piece of that effectiveness. It protects them to some degree from political pressures and makes it easier for them to take the rule of law decisions in critical cases and to move our country forward. So I'm bullish on the federal judiciary and in the rule of law context. Yeah.
You mentioned specifically with some of the tribunals that there seemed to be more impact when they were patriated, or at least when a lot of the efforts were patriated, that there was, for instance, that the decisions of the ICTY, although the rest of the world paid attention, in the former Yugoslavia, the impact was minimal, whereas the War Crimes Chamber in Belgrade seemed to carry a lot more weight. Do you see that being the model going forward? I know there's a long dispute, this comes up a few times a year here, of do we keep with a model of international tribunals authorized by the UN, like the ICTY, or do we move toward a hybrid model like Sierra Leone, or even some proposals where if there is ever a tribunal for Syria or Libya, that it would be either, like in Cambodia, patriated with UN help or completely patriated?
So I am of the view that you tools in your toolbox as possible, so I wouldn't rule out any of them. And I think what's important from my perspective is understanding the context in which you're operating and which of those different tools is going to have the biggest rule of law impact over time in that context. And I think what's important is some flexibility between them and capacity to actually deploy them simultaneously. So for example, to develop capacity for national accountability that it could complement international accountability, and then mechanisms for transferring cases from an international court to the national court, or holding proceedings of the international court locally so that it's more demonstrable for the local population. So, you know, the threads I think I want to pull here or emphasize are the importance of context-specific solutions and for localizing the process. Yeah.
Hi, so my question's coming a little bit out of my own experience working in post-conflict development, but you spoke a lot about state action being key to improving localized rule of law, and I just was kind of wondering your opinion about when a state is effectively preventing that kind of dialogue, preventing that kind of dialogue by creating a culture of silence where people aren't talking about things that happen and are afraid to talk about those things. What kind of tools are in the toolbox for dealing with that kind of issue?
Well, it really depends on, how effective the state is in silencing local populations. We do a lot of work with civil society, supporting civil society, convening civil society for conversations, and where that can be done safely for the participants, that's useful. The internet is a great resource in this context, and those states, try to block it. I think, the tide is against them. And there are lots of opportunities for kind of distance learning or distance engagement. And then exchange programs, opportunities that, for reformers, leaders of those kinds of efforts to travel abroad and be exposed to different ideas and have opportunities to interact with other folks in a less kind of repressive environment is always a positive where you can do that. But you're absolutely right, there are contexts in which that are very, very closed where that can be very challenging.
You talked a lot about community development and involving the local community, and knowing a lot of the history of conflict, a lot of it has had to do with ethnic conflict, tribal conflicts, and sectarian conflicts. And so I'm wondering, in that toolbox, in the way of conceptualizing things, Have you guys integrated local political structures in terms of tribal networks into a rule of law apparatus and kind of created more of a formal structure out of something that already exists on the ground?
Absolutely. In fact, that's got to be almost a starting point, is that you engage local leaders in the participatory approach to transitional justice in the consultations, but importantly not stopping there, because often we find those traditional structures will leave important voices marginalized or out of the conversation. And so it's important to kind of set some ground rules for the consultation, that it needs to be a representative process, and that there will be individuals of marginalized groups that will be identified to participate as well. So yes, engage those structures, but don't limit yourself there. One related issue that we've had to grapple with and again develop kind of context-specific solutions is, and it really depends on kind of how recent the violence is, kind of how raw it is, but you know, in a consultation about a way forward, a reconciliatory process, it can be ideal if you can have perpetrators and victims coming together. But obviously that can be very charged as well, depending on the context. So that's another set of questions that need to be asked and answered in the individual context.
How would you address local communities that culturally reject a development of the rule of law initiative or transitional justice, and it's not an oppressive power or perhaps opening their eyes, but an actual fundamental cultural pushback against that?
Well, you cannot force this on a community. What we've found more often than not, though, is even where you think it may be an alien concept or a foreign concept, that there is justice is kind of a pretty natural impulse, and when you start to talk about it in terms that are locally resonant, that usually folks want to be a part of that conversation. So you know, but you're absolutely right, they have to come to the table. But we have found that if it's framed in terms that are meaningful to them and their realities, that there's not a lot of resistance.
Time for one last question.
What are some strategies that you use when a population becomes more disenfranchised and no longer has that push towards justice? I'm thinking specifically of the Cambodia Tribunal, which is currently, the government has said that we're going to stop, we aren't going to do cases 3 and 4. There's been not too much public pushback, and there's various reasons for that, but what can the Rule of Law Initiative do in that case?
Well, I can't speak to that specific example, except in the abstract. I think one of the ideas that I'm trying to advance here is, again, kind of widening the perspective on solutions. So it may not be that a trial is possible, but there may be other kinds of awareness raising, truth seeking, truth testifying processes that can be importantly resonant, kind of reset an understanding of what is right and wrong, what was right and wrong, in ways that are really important for going forward. So I think an important part of this reconceptualization that I'm suggesting is, in fact, a much more prospective orientation than a retrospective orientation. And making sure that the understanding of what happened informs a more constructive future. And I think cultural kind of activity and institutions can be really important educational programs, that sort.
Everybody, thank you. We would love you to join us for a reception around the corner. We do have hors d'oeuvres and drinks, and you'll have a chance to talk with Betsy Andersen. So please join us.
Thanks.
That's terrific. Thank you.